So I would like to thank everyone who came in person, and also I would like to thank everyone, those who are online for BIOMES. So my name is Brendan Lewis. I am a second-year PhD student in the School of the Environment. I'm also co-lead for the BIOMES committee, and if this is your first time at BIOMES, welcome. Now, BIOMES is a community source seminar series. We talk about different issues in environmental science and methods. So we invite many different speakers to cover these issues also as part of the series. So today we have a really great speaker and we're excited. For those who signed up for the lunch with Dr. Kysar, please remember that we have lunch on the second floor. So now I'll give a short introduction to Dr. Doug Kysar. So Professor Douglas Kysar is Joseph M. Field Professor of Law at Yale Law School and is the faculty co-director of the Law, Ethics, and Animals program. His teaching and research areas include torts, animal law, environmental law, climate change, products liability, and risk regulation. Kysar was previously on the faculty at Cornell Law School. He received his BA summa cum laude from Indiana University in 1995 and his JD magna cum laude from Harvard Law School in 1998. Following law school, he clerked for the Honorable William G. Young of the United States District Court for the District of Massachusetts. And help me welcome Dr. Kysar.
Thank you, Brandon, for that very nice introduction, and thank you to all the BIOMES committee members for organizing this, and thanks to all of you for being here. I suspect a lot of you are just here to save your seats for Wakanda Forever later tonight, but that's okay. Sit tight. I think you'll enjoy the talk. When I was invited to come over and share some of my work with you, I thought about sending over this title for the lecture. A whodunit, of course, is a story about a crime and the attempt to discover who committed it. And my talk was going to examine climate change through the lens of a whodunit novel, because I think different strands of climate litigation can be seen as efforts to develop compelling narratives about who bears primary responsibility for the climate crisis, which is surely one of the greatest crimes humanity has ever committed. But on reflection, I decided that title was both too dark with its reference to the end of the world and also too flip with its characterization of gravely serious climate advocacy efforts as being analogous to writing mystery novels. So instead, I've gone with this much more sober title, but there's still a little bit of a wink in the title, since I mean judging responsibility to bear two meanings. First, the actual act of judging responsibility, that is, judging cases that pose the question, who bears responsibility for climate change? But second, judging with responsibility, that is, the obligation of judges to continue to fulfill their role within the Anthropocene and not to shrink in the face of daunting late modern challenges like climate change. So I want to discuss in particular how civil courts will grapple with scientific and normative complexity in cases that address climate-related harms. Specifically, I want to explore implications of the field of attribution science for tort law adjudication. Climate attribution science can be defined broadly as the scientific study and estimation of causal responsibilities for the drivers and impacts of climate change. There are related but distinct questions that arise within the field of climate attribution. First, there's what we might call warming attribution. How much of observed and projected climate warming is attributable to greenhouse gas emissions that are associated with human activities, separated out from other drivers of planetary temperature change? Second, impact and extreme event attribution. To what extent has climate change caused or increased the likelihood of various impacts on social and natural systems? including extreme events like hurricanes, wildfires, droughts, and floods. And finally, and most pertinent for tort law, what portion of climate change and its impacts can be attributed to the choices and actions of specific individuals, companies, nations, or other identifiable human sources? Now, scientists and researchers are improving their capacity to answer all these questions with specificity and confidence. Their work is beginning to affect how the public and policymakers perceive the urgency of the climate crisis. As I'll explain in this talk, these developments also hold significant implications for climate change litigation and the field of tort law. Over time, the reality of climate change and its attendant harms will influence judicial practice at the most fundamental level. To some extent, it already has. When we take warming attribution as an example, the 5th and 6th assessment reports on the state of climate science through the Intergovernmental Panel on Climate Change has laid to rest any lingering uncertainty regarding the role of human activities in causing harmful climate change and the need for a dramatic shift of course to avoid severe planetary disruption. The role of warming attribution in climate change litigation is straightforward, but it's highly significant. When the empirical reality of human-caused climate change is posed as an issue within a lawsuit, such as when climate impacts are asserted by a plaintiff to establish their standing to bring a claim, or when the adequacy of an environmental impact statement is being challenged because it fails to consider greenhouse gas emissions. When those happen, courts are put in a position to affirm the epistemic legitimacy of climate science. A notable example of this occurred in the second sentence of the United States Supreme Court's majority opinion in 2007, Massachusetts versus EPA, where Justice Stevens emphasized that warming attribution is accepted by respected scientists, a pointed phrasing that had implications for the broader public acceptance of climate science, because the legitimacy of courts is premised on independence and responsiveness to reason and evidence. That pointed phrasing by Justice Stevens reached beyond the specific parties and the narrow administrative law question posed in the case, and it instead affected larger societal and political discourses. Given that we have a continuing challenge of effectively communicating the reality and significance of climate to lay people, securing these independent judicial affirmations of climate science remains a significant motivating factor behind much climate change litigation. An interesting example from Europe came in a ruling by the German Constitutional Court in 2021, which has been seen as a significant endorsement of the importance of limited carbon budgets as a conceptual basis for government planning and legal obligation. Now, the effects of the other climate attribution science categories, source, impact, and extreme event attribution, these are more speculative for climate litigation, and they'll be the primary focus of my talk. The categories of attribution science will be discussed in the order that I just listed them, because together I think they tell a story about the limits and the future potential of litigation against the backdrop of widespread and often quite severe climate-related suffering. Now, in the United States, the most high-profile climate change tort suits have sought to hold major fossil fuel companies responsible for present and anticipated costs relating to climate change. These have often been brought on behalf of governmental plaintiffs, such as cities and states, as well as some private plaintiffs, such as a fishing industry trade group. These lawsuits allege public nuisance and related tort law claims. They argue that the fossil fuel industry has known for decades that its products contribute to global climate change while simultaneously foiling government action through misrepresentation, deceit, and aggressive lobbying tactics. Under US law, to prevail on a public nuisance claim, the plaintiffs will need to show that defendants unreasonably interfered with a right common to the general public via instrumentalities under the control of the defendants. A somewhat similar legal framework will apply to claims that have recently been brought by German environmental NGOs against major German automakers. A variety of doctrinal questions arise from this attempt to configure climate change as a public nuisance, including the question of whether a stable climate system is in fact a right common to the general public. So in that sense, private law climate suits can be seen to overlap with the important normative questions that are raised by human rights lawsuits and constitutional climate change lawsuits. Here, though, I want to focus on the question of whether the fossil fuel defendants control the relevant instrumentalities that are causing climate change, as that question directly implicates the source attribution field of scientific study. These current carbon majors tort actions followed an earlier wave that were filed unsuccessfully in the early 2000s. These more recent filings seek to capitalize on factual developments in two key areas that are of potential relevance to industry liability. First, a series of academic and journalistic investigations uncovered a substantial amount of evidence regarding the extent of the fossil fuel industry's long-standing internal knowledge of climate science and the grave threats posed by greenhouse gas emissions. Second, the field of source attribution has developed such that plaintiffs can now portray fossil fuel defendants as being responsible for human-caused warming and slow onset effects like ocean acidification, and even specific climate-related events with a precision that was previously unavailable. Now, the carbon majors lawsuits call to mind litigation against the tobacco industry, which also sought to shift societal perceptions of a deeply entrenched industry by focusing on the alleged callousness and deceit of those who profit by its prevalence. Whether this narrative of industry culpability will stick depends somewhat on whether plaintiffs will reach the discovery and trial phases of litigation. To date, the suits have been mired in disputes over venue and other preliminary procedural matters. Fossil fuel defendants have uniformly sought to remove their cases to US federal courts as opposed to state courts, despite the complaints being filed by the plaintiffs under state law. The defendants anticipate a friendlier reception in federal court, in part because of very stringent requirements on standing and what we call justiciability. But they also have a perception that federal judges are more likely to view state tort law as an inappropriate body of law for addressing climate change. One case that appears to confirm that perception is a case called City of New York versus Chevron. In this case, a federal appellate court addressed state tort law claims brought by the City of New York against 5 multinational oil companies. The city was seeking damages for harms and expenses suffered by the city due to climate. The panel first held that global warming presents a uniquely international problem of national concern, and therefore must be addressed only by federal common law rather than state common law, in this panel's opinion. The panel then held that federal common law is displaced by the US Clean Air Act, even when a litigant is merely pursuing a claim for damages rather than some sort of injunctive relief that would be in tension with the EPA's actions under the Clean Air Act. Central to the court's reasoning was a concern that plaintiffs had ulterior policy goals in bringing the suit. They were actually trying to achieve regulatory goals in court that they were failing to achieve in Congress or through the agencies. Now, whether or not the panel was correct to have that concern, the twin holdings of the court had the effect of precluding entirely the application of judge-made law, whether federal or state common law. That has been wiped out, at least by that panel. A similar withdrawal of normative authority by judges occurs in the public law case of Juliana versus United States. This is, of course, a case where youth plaintiffs are alleging the United States government has violated the plaintiff's constitutional rights by promoting fossil fuel production despite decades of official awareness of the catastrophic dangers posed by climate change. In Juliana, a federal appeals court panel held the plaintiffs lacked standing to bring their claims because the court held the alleged injuries are not redressable through judicial relief. In order to reach that conclusion, the panel seemed to view redressability as requiring judges to somehow solve climate change, rather than merely to offer the kind of relief that the remedies had requested, that the plaintiffs had requested. Strikingly, the Juliana panel even discounted the importance of declaratory relief, that is, relief in which judges simply declare the existence of a right and its violation. The judges reasoned that judicial acknowledgement of a constitutional right to climate stability would only benefit the plaintiffs, quote, psychologically, which the panel did not believe was a weighty enough interest to support invoking judicial authority. In ruling this way, the panel seemed to adopt the same skepticism of climate litigation that was shown in the City of New York versus Chevron case. They described plaintiffs' claim as a demand that judges devise, quote, a comprehensive scheme to decrease fossil fuel emissions and combat climate change, rather than an effort to enlist the traditional role of judges in declaring rights and responsibilities against the backdrop of climate change. Now, a very different judicial attitude was on display in the first state court opinion in the US to address a motion to dismiss in one of these carbon majors lawsuits. Hawaii trial judge Jeffrey Crabtree, who interestingly serves as a designated environmental court judge in Hawaii. Coincidence? I think not. He handily waved away the fossil fuel defendants' arguments that the cases somehow required a suspension of ordinary common law processes. Particularly in the context of tort law, judicial hesitation to engage with the merits of climate change claims is unwarranted, because tort law contains within it ample doctrinal machinery with which to manage even a vast and seemingly unfathomable issue like climate change. For instance, assuming that one or more of these cases ever did make it to the merits, a contested critical element will concern how to assign and apportion liability in light of the vast number of actors who can be said to have caused climate change. This, of course, is where the field of source attribution comes in. A number of research groups are dedicating time and attention to determining which entities are responsible for which percentage of historical greenhouse gas emissions. A groundbreaking study in 2014 concluded that nearly 2/3 of the CO2 emitted since the 1750s can be traced to the 90 largest fossil fuel and cement producers, most of which still operate today. Though they haven't yet been named as defendants in climate lawsuits, the heavily concentrated industrial animal agriculture industry also has been subjected to source attribution studies. Researchers estimate the 5 largest global meat and dairy companies collectively are responsible for more annual emissions than Exxon, Shell, or BP. These source attribution studies take anthropogenic climate change, which is the mother of all collective action problems, and they reduce it from a problem seemingly caused by several billion past and present human individuals to instead one driven by a few dozen companies. So as such, they're trying to make climate change appear to be more amenable to traditional tort law adjudication. So if judges were persuaded by this characterization, they could utilize the source attribution studies, the calculation of emissions responsibilities, as a basis for apportioning damages for climate-caused harms. The approach would be similar to what we call market share apportionment, which has been utilized in products liability claims and groundwater contamination scenarios that involve a large number of defendants. Rather than relying on market share as the basis of allocations, courts would use the metric of historic and continuing responsibility for greenhouse gas emissions. Now, courts could do that. Will they? Will they find this characterization of climate responsibility to be persuasive? A critical matter of judgment will concern whether the fossil fuel defendants should be held accountable for emissions that occur throughout the entirety of their company value chain, or instead only for the emissions that are more directly under their control, like through exploration and drilling activities. Within this field of corporate climate reporting, emissions from owned or controlled sources like oil and gas production are considered to be Scope 1 emissions. Greenhouse gases attributable to purchased electricity, heating and cooling, and other energy services are considered Scope 2 emissions. All other indirect emissions occurring along that value chain are considered Scope 3 emissions, including those releases that occur when an end user burns coal to run their power plant or gas to drive their car. For fossil fuel companies, Scope 3 emissions are especially significant since the vast majority of their total related emissions fall in this category. So the question arises whether those emissions should be attributed to the fossil fuel defendants rather than to their customers or to the government that authorized and supported their production. Some published opinions in the US climate litigation space appear to recognize this attribution question. In the City of New York versus Chevron case, the panel noted pointedly that, quote, every single person who uses gas and electricity, whether in traveling by bus, Uber, or jitney, contributes to global warming. The court seemed to be asking why the City of New York singled out 5 multinational oil companies for responsibility when billions of humans have been participating in the fossil fuel economy that those companies enable. The difficulty for plaintiffs here is that all humans are embedded in systems that give rise to greenhouse gas emissions. As the youth plaintiffs in Juliana have also shown, governments at the highest levels have promoted and supported those systems despite knowing for decades of the catastrophic risks that they entail. So why are the carbon majors more causally responsible for climate change than the governments that authorize and subsidize their activities, the manufacturers of the vehicles, equipment, and other products that utilize fossil fuels, or the consumers who ultimately benefit from them? Plaintiffs in these carbon majors lawsuits have a couple of different responses to this difficulty. First, as noted earlier, they aim to present evidence of fraudulent and deceptive practices by the fossil fuel defendants in order to lessen the perceived causal responsibility of end users and lawmakers. Just as smokers might be seen as less responsible for the health hazards of tobacco use in light of industry efforts to manipulate public awareness and government policy, carbon major plaintiffs hope to portray Scope 3 emissions as the natural and proximate effect of manipulative behavior by the fossil fuel industry. Second, plaintiffs also can take a more pragmatic turn and draw on existing examples from the environmental context, which have succeeded by taking a liability-based approach to the question of simply, as a practical matter, how do we marshal capital toward underfunded environmental needs? Most notably in the US, the liability scheme known as Superfund requires parties responsible for hazardous waste contamination to pay cleanup costs and other associated damages. Superfund casts an extraordinarily wide net when defining potentially responsible parties, including people and entities currently in control of a facility, even if they weren't in control of the facility at the time of the waste release, people and entities who were in control at the time of the release, people and entities who arrange the transportation and disposal of hazardous waste, and transporting parties who chose the location for disposal. The aim of the statute is simply to look broadly through a hazardous materials history and value chain in order to identify a deep pocket that can help remediate a dangerously contaminated site. Notably, although Superfund was established by a statute, lawmakers drew heavily from common law tort principles when they crafted the liability scheme at the heart of that statute. So the Superfund analogy offers a way of understanding the relief being sought by climate change plaintiffs. Plaintiffs are expressly disclaiming any intent to use the judicial process to achieve a greenhouse gas regulatory system. Instead, they simply seek compensation for expenses that are stemming from the impacts of climate and the need to adapt to those impacts. Just like in the Superfund context, the question simply is, how do we marshal the necessary funds? From the plaintiff's perspective, the fossil fuel defendants' causal role in contributing to the harm marks them as potentially responsible parties who should help shoulder the massive public costs of adapting to climate. Whether courts will find that characterization persuasive is an open question. The returns to date suggest a great deal of skepticism, at least among US federal judges. As the cases slowly make their way back to state court, though, plaintiffs remain hopeful at least some judges will agree with Hawaii Judge Crabtree that the actions can be seen as good old-fashioned tort suits despite the extraordinary factual backdrop. Now, in the remainder of the talk, I want to take that viewpoint a step further. I want to ask, how will tort suits that really are old-fashioned change as the impacts of climate become ever more pronounced and pervasive? That is, so put aside for a moment the trillion-dollar question of who bears liability for causing climate change. How will the reality and severity of climate affect more garden variety claims of wrongful behavior? As the state of climate attribution science grows in certainty and coverage and detail, it will become increasingly likely that in order to avoid being deemed wrongful under tort law, actors will need to take account of climate and its impacts in their decisions and actions. A central premise of tort law is that actors hold a duty of care to guard against the reasonably foreseeable risks of their conduct. Put succinctly, climate change will expand the scope of risks that are reasonably to be foreseen. For instance, in the wake of that deadly collapse of a 12-story condo building near Miami Beach in 2021, investigators and regulators have focused on the potential role of climate in making those disasters more likely, as sea level rise and saltwater intrusion and flooding and extreme weather combine to stress the structural integrity of coastal buildings. Under standard principles of tort liability, property owners owe a duty of care to residents and other guests that includes guarding against hazardous conditions the owner could discover through reasonably careful investigation. Case law hasn't developed on this point yet, but that investigation, that reasonably careful investigation, I would argue, includes, at this point, consideration of how the present and foreseeable impacts of climate will threaten the safety of properties. In addition to property owner liability, you could easily imagine tort law evolving to include consideration of climate-related risks as a routine aspect of exercising professional judgment. A lawsuit currently pending in the US against Exxon challenges the company not for its direct contributions to climate change, but for failing to comply with good engineering practices under the Clean Water Act. The plaintiff, an environmental group known as the Conservation Law Foundation, alleges that Exxon has failed to consider climate impacts in its stormwater pollution prevention plan for the company's petroleum storage and distribution terminal in places like Everett, Massachusetts. This is despite the company having taken efforts to secure other company-owned property that it considers more valuable, like offshore drilling equipment. So as a result of this dual standard within Exxon, the lawsuit alleges, the Massachusetts terminal is vulnerable to climate-related flooding and toxic chemical releases that will harm surrounding poor and minority neighborhoods. This is a failure to adapt claim, and it could also begin to be made under tort law against all sorts of professionals, engineers, architects, planners, and others whose professional expertise concerns the built environment. In 2014, for instance, an Illinois insurance company filed a lawsuit against several municipalities, arguing that their failure to consider climate-related heavy precipitation events in their stormwater management plans led to excess flooding payouts owed to the company's policyholders. Notably, it should not be a defense in any such action that the defendant relied on building codes or floodplain maps or other official records that have not been updated to take account of present and projected impacts of climate change. The inadequacy of those existing records is widely understood. Lawyers, accountants, investment managers, other financial professionals might also begin to incur liability for failing to incorporate climate impacts into their relevant areas of professional judgment. An intriguing example comes from Australia, where a worker sued his pension fund, arguing that the fund's managers failed to provide information about and prudently guard against threats posed by climate change to the long-term value of the fund's investments. The fund settled with the plaintiff by adopting a new climate risk disclosure practice, by committing to net zero emissions by the year 2050 for its portfolio, and agreeing in a statement that, quote, climate change is a material, direct, and current financial risk to the fund. As regulators and institutional investors around the world move toward a regime of more formalized and extensive climate change risk disclosure obligations, the role of litigation in policing those disclosures will become significant. Companies, and in some cases their professional advisors, may face liability to investors, consumers, and others who rely on inadequate or misleading disclosures. So premises liability and professional malpractice are just two examples of a broader phenomenon. I think the manner in which courts assess all tort duties will be impacted by the fact that we live in an era of elevated risk due to climate. The US judge Learned Hand famously conceptualized the duty of care in tort law as a function of three variables. In many areas that are of relevance to tort law, climate is raising both the probability of an adverse event and the magnitude of harm if that event occurs. For instance, consider the problem of wildfires, which around the world are increasing significantly in scale and duration, due in large part to climate-related impacts like heat, drought, and lightning increase. As a result, both the P and the L associated with activities that might lead to fire outbreaks have increased, therefore leading to a larger set of burdens, or B, that defendants should take in order to avoid being deemed negligent. Indeed, it is possible to imagine climate impacts shifting the risk level associated with an activity so significantly that the activity becomes to be seen as abnormally dangerous, and therefore an activity that is appropriately subjected to a strict liability standard rather than merely a negligence standard of culpability. Returning to the wildfire example, we might ask what kinds of activities might come to be seen as abnormally dangerous in the near future, given the significant fire risk they pose even when reasonable care is exercised. Fireworks displays, for instance, are typically not in US law subjected to strict liability. That's at present, but might that assumption change in the future, at least for states that are heavily threatened by wildfires? What about campfires and cigarette smoking, which may have been in common usage at one point in such areas, but becomes increasingly shunned as an unnecessary fire hazard in the coming climate century? The point is not to answer questions like that at present, but to begin to locate them on the horizon and to consider them as examples of a wider dawning of climate change awareness that will impact tort law in coming decades. Whatever may become of the high-profile suits that seek to hold fossil fuel companies or governments responsible for causing climate, the sheer pervasiveness and magnitude of climate impacts will ensure that the tort system has to grapple with how we adapt individual duties of care in a world of collective recklessness. Of particular challenge will be events of vast destructive scope. On the one hand, climate modeling is becoming ever more precise and rapid, allowing scientists to conclude extreme event attribution studies within days of a potentially climate-related event occurring. For instance, when severe flooding struck Western Europe in the summer of 2021, scientists working in the World Weather Attribution Network were able to quickly estimate that anthropogenic climate change made the event 1.2 to 9 times more likely to have occurred. More dramatically, the extreme heat events in Siberia during 2020 and the Pacific Northwest of the US and Canada were found by scientists to have been virtually impossible without the influence of human-caused climate change. Given tort law's preponderance of the evidence causation standard, which asks whether a challenged conduct was more likely than not to have caused a harm, these attribution analyses are kind of tailor-made to support legal attribution of an extreme event to anthropogenic climate change. However, these analyses leave in place the source attribution problem that we discussed earlier. They only identify humanity as the causal agent behind an extreme climate-related event, rather than some legally accountable subgroup of humanity. Even in tort law, when an individual defendant is identifiable as the causal culprit behind an event of mass destruction, tort law historically has been reluctant to hold defendants responsible for the outsized consequences of their shortcomings. A prominent example in the US is the case of Strauss versus Bell Realty, which arose from a massive electricity blackout suffered by New York City in the summer of 1977. This was due to the fault of Consolidated Edison, Con Ed, the electric utility. Among those harmed was a 77-year-old plaintiff named Julius Strauss, who ran out of water in his apartment building which was supplied by an electric pump. Strauss fell and sustained severe injuries as he attempted to descend down an unlit stairwell to fetch water from the basement of the building. He brought suit against his landlord, but also Con Edison. Earlier litigation had established that Con Edison was grossly negligent in causing the blackout. So the court should have only had to decide the extent of their liability to Strauss. Still, the lawsuit seemed to rattle the New York Court of Appeals. In a remarkably candid opinion, the Court of Appeals dismissed the complaint explicitly on, quote, public policy grounds. In the face of what it called liability, which could obviously be enormous, the court said it made a decision which was, quote, not governed by tort or contract law principles. In other words, they just decided not to apply the law. What exactly did the judges of the Court of Appeals fear? A dissenter pointed out that Con Edison could easily distribute any cost among its consumers in the form of higher rates. In response, the majority only vaguely alluded to, quote, the societal consequences of rampant liability. Well, turnabout is fair play, as the saying goes. Con Edison received its due nearly a quarter century later, when disaster again struck New York City, seeking to recover damages for its electricity substation, which was destroyed after the 7 World Trade Center building collapsed from a fire set during the 9/11 tragedy. Con Edison alleged the building had been negligently designed because the applicable safety codes required such structures should be able to withstand uncontrolled burning without collapse. That was the applicable safety standard. The appellate panel, however, fixated on the fact that the particular fires at issue on 9/11 had been caused by an unprecedented terrorist attack on the neighboring Twin Towers. Indeed, the court likened the events to, quote, a fire triggered by a nuclear attack on Lower Manhattan, clearly implying that ordinary rules of negligence would be suspended in such an event. Technically, the court deemed Con Edison's claim deficient for failing to establish causation, but that reasoning was utterly unpersuasive, as a dissenting judge amply demonstrated. What truly drove the majority's decision was a sense that tort law was simply usurped by what it called the unprecedented ideology and severity of the cataclysm that engulfed Lower Manhattan on September 11th. Judicial reticence in the face of such massive, unimaginable events is understandable, but climate change raises the prospect of catastrophe that becomes routinized and therefore in need of being incorporated into the ordinary operations of law. 18 of the 20 largest wildfires recorded in California history have happened in the most recent 2 decades, with 8 happening in the most recent 2 years. Each of the previous 7 years have established records for ocean temperature, a critical reason why hurricanes are increasing in intensity and impact. Hurricane Harvey in 2017 dropped as much as 60 inches of rain on the city of Houston, causing damage to more than 100,000 homes, 125 billion in total losses. In 2021, 50 people drowned when the remnants of Hurricane Ida overwhelmed urban stormwater drainage systems in the US Northeast. According to NOAA, the US in 2021 experienced 20 separate billion-dollar climate and weather disasters, second only in number to the record-setting year of 2020. Reflecting on these trends, the agency noted, it is concerning that 2021 was another year in a series of years where we had a high frequency, a high cost, and a large diversity of extreme events that affect people's lives and livelihoods. Concerning because it hints that the extremely high activity of recent years is becoming the new normal. Negligence attends these tragedies, even if the role of climate change seems to overwhelm individual human agency. In Houston, for instance, city planners relied on rainfall records that were 2 decades old prior to Hurricane Harvey, despite clear awareness that urban flooding events had been rising for years. If tort law continues to shirk in the face of catastrophe, even as those events become agonizingly familiar, then the common law will begin to cede much of its normative power. Consider as a final example a case that arose from the devastating Katrina hurricane of 2005. In the case of Barasich versus Columbia Gulf Transmission, residents of southern Louisiana sought damages for personal injury and property loss they claimed was caused by oil drilling and pipeline construction. The complaint alleged the defendant corporations had destroyed millions of acres of marshland through their dredging and drilling operations, thus decimating a crucial protective barrier against storm surge. Interesting, the plaintiffs in this case were not trying to link the ferocity of the hurricane to climate change or the defendant's oil and gas production to climate change. Rather, they were relying instead on the direct conduct of the defendants in destroying protective marshland, which under Louisiana's capacious negligence standard should have subjected those actors to liability. Despite this carefully circumscribed theory of liability, the district judge granted the defendant's motion to dismiss. The court rejected the notion the case presented a non-justiciable political question, but nevertheless held that plaintiffs failed to state a claim of negligence. The court offered multiple reasons for its decision, but it centered on issues of proximity. It narrowly construed the principle that trespass and negligence must lie only among neighbors. They viewed the plaintiffs as distant strangers to the fossil fuel defendants, whose activities had nevertheless powerfully shaped the entire coastal environment of the Gulf, enhancing storm surge risk for all of the area residents. The court nevertheless emphasized the defendants were, quote, physically and proximately remote from plaintiffs and their property. In a revealing conclusion, the court accepted the plaintiff's basic premise, but recoiled from the suit's spatial and temporal complexity, inviting the plaintiffs instead to refile with a, quote, less ambitious lawsuit. In other words, the lawsuit seemed to fail not because it contravened traditional tort principles, but because it took those principles to their logical conclusion. The plaintiffs reached a point where the weight of the case moved it from the domain of tort to politics, from adjudication to legislation and regulation, where the scale of harm overwhelmed the perceived capabilities of the common law or the nerve of the judge. Judicial failure to engage tort law's norm articulating capacity in the face of climate catastrophes is regrettable, because the climate crisis is driven in substantial part by an absence of shared norms of responsibility. Put plainly, the mother of all collective action problems stems from the assumption that no law, policy, or principle prevents the dumping of waste into the sky. Now, as the sky has begun striking back, we face a similar normative vacuum when addressing responsibility for the suffering induced by climate disasters. Confronted by that vacuum, tort law could play a role in the development and enunciation of norms of responsibility. The role does not need to be decisive. Legislatures could always choose to revise or repeal common law pronouncements within constitutional boundaries. But active judicial engagement with the challenge of developing norms of responsibility in the climate era is more reasonable than the alternative. Indeed, if judges in the United States would only look outside their borders, they would see many examples of responsible judging, brave judging, happening in The Hague and elsewhere around the world. They would see that the sky has not fallen on those courts despite their bravery. Even in the most optimistic scenario of climate change mitigation, we are destined for at least the next 3 decades and likely much, much longer to have continued warming with accompanying mostly negative impacts. Harm will be pervasive and often devastating. Attribution science, with its unequivocal linking of human activities to climate change and climate change to harmful impacts, eventually will settle into lay and judicial epistemologies. The ultimate question of who bears responsibility for putting humanity into this plight will remain contested and unlikely to be met with definitive judicial resolution. But our duties of care and regard for one another in an era of routine, predictable, and extreme harm will necessarily evolve. Whether by choice or by necessity, we will become accustomed to judging care in a reckless world. Okay, thank you. I didn't mean to go on that long, but I got a little worked up. Would love to take questions if anybody has any.
Thank you. It's very interesting. So I'm curious, the examples you used for the courts balancing risks in liability were largely physical risks. There's also this whole concept of transition risks. And a given action might reduce physical risks, but increase transition risks. You could think about reducing heating oil for low-income families, might reduce climate risk, but puts certain populations at risk. How do the courts go about balancing those competing risks? Like what tools should scientists be thinking about in the way that courts will deal with those sort of competing risks?
So it's interesting because typically in a negligence case, we're only looking at the marginal costs and benefits of an alleged failure on the part of the defendant. So, not a macro assessment of all the different costs and benefits of, say, fossil fuel fired electricity. So the transition risk issue, it wouldn't necessarily be squarely posed if we were challenging, if we're challenging a utility for coal-fired emissions and their contribution to an extreme event, for the utility to defend by saying, yeah, but if we stop production right now, then there's going to be people who can't heat their homes because the alternatives are too expensive and they'll get priced out of the market. That wouldn't necessarily be relevant and admissible evidence because the way the plaintiff would frame the case is very narrowly focused on challenging a particular conduct causing a harm. And that might be reason why a court would, be reluctant to step into this space because they might be aware of arguments like that and concerned that allowing the case to go forward would have these sort of like unintended negative ripple effects that are outside the court's purview. But I want to give some more thought to that because I'm a tort romantic and also someone deeply concerned about the climate crisis. I didn't hypothesize transition risk plaintiffs in thinking through these issues, but I will now. Thank you for that question.
Doug, thank you so much. Tour de force. My question, I just wanted to draw you out a little bit for the points that you made very quickly at the end, namely the cases in Europe that have been quite remarkable and almost one after another and don't get much attention in the news, even in the climate change circles here in the US. And I'd love to hear your reasons for that. But this is, we are in such a climate bubble here in the US, still with denying and so on and so forth. And I'm not saying Europe is perfect, but the rest of the world is way ahead on these issues, and they have been for quite a long time. Attribution in Japan, typhoons and so on, that has been for a long, long time. Anyway, why do you think those cases have been ignored?
Well, why are they ignored in the US? I would say just because we're famously not a cosmopolitan culture, and we ignore most of what's happening around the world. For me, an interesting question is, well, why is the judicial approach to climate lawsuits so different and so much more seemingly, willing to engage with the merits and take bold action, including holding governments accountable for inadequate climate ambition? We've seen multiple Supreme Courts of countries do that. In part, it's those legal cultures are just fundamentally different, where there's a kind of basic notion of a duty of care that a government owes to all its people, right? A duty of kind of like protection. And we're a famously kind of classical liberal constitutional culture here that intentionally hobbled our government. We intentionally made our government inefficient and slow and unlikely to act because we thought concentrations of power in the public sphere was the greatest threat to our well-being. In other countries, like in Germany, there's more of a sense that the government acting proactively to provide protection of publicly shared goods like atmospheric stability is part and parcel of the government's job. So we have a kind of just a cultural mismatch there. But to give the other side of the argument, it's a very limited and difficult to manage tool, judicial action in the face of something that really requires systemic, across-the-board transformational change, right? So a very prominent example of this is the court in the Netherlands, after first holding its government accountable for inadequate climate ambition, then held Shell accountable. And that was one of the first actions in which a corporate entity was held liable for basically failing its duty of climate care. And Shell responded first by moving its corporate headquarters to England, and then second by selling $10 billion worth of gas assets in the Permian Basin to ConocoPhillips. And arguably emissions went up because Conoco is a much, much shoddier actor than Shell when it comes to fugitive emissions and methane. So arguably, the court's ruling increased greenhouse gas emissions despite the headlines that it attracted everywhere else but in the United States. So and I don't mean that to say that judges shouldn't do bold things like hold corporations accountable, but it needs to be the beginning of a conversation that prods legislatures into action to comprehensively regulate the industry so that you can't have this whack-a-mole problem. I run a animal ethics program over at the law school, but I still use whack-a-mole. They permeate our language. Our language is very violent.
We have time for one more.
Hi, first I want to say thanks for the chat, and I appreciate the discussions about legal doctrine being a little bit squishy, for lack of a better word. I have been interested in the standing doctrine for some time, and I'm curious about your thoughts on its consistent narrowing over the course of time, and what implications that has on the legal culture going forward. And kind of a related question to that is you talked a lot about how the legal culture is just different in the United States compared to these other countries. And I think the standing doctrine is reflective of that. How can we change the legal culture? Or do you think that this just needs to be something that's addressed like outside of that? Yeah.
Thanks. It's a great question. Yeah, I mean, for one thing is we need to be very assertive and intentional about who we put on the federal bench. The federal judiciary over the past 4 decades has moved dramatically in a conservative fashion, and the rise of standing limitations is part of that. It's an effort to block access from mainly civil society groups, NGOs, to the courts because they're trying to hold government accountable for failing various duties under statutes and otherwise. It's even kind of like now in these tort suits that I'm talking about, it's kind of metastasized in strange ways. Like the standing idea borrowed from the common law of tort in applying principles like you need injury, causation, redressability in order to show that you have standing to challenge an agency's action. That was devised in order to limit who had access to the courts to challenge administrative law, to challenge regulators. But now, and they borrowed it from tort law, now the courts in climate tort suits are putting it back. They're taking it back from there and applying it to the common law itself. And that's how you have a case like the Juliana case or the Kivalina case earlier, saying plaintiffs don't have standing to bring a tort suit, when what they need to say is you don't have a tort, you don't have a viable claim on the merits, but instead they've created a whole nother miniature trial before the trial. And they're doing it just to create barriers to accessing the judicial power. And there's numerous other examples that we can, the erosion of class actions, the raising of pleading standards, like it just goes on and on. So how do we combat that? That's why I give such a shout out to Judge Crabtree in Hawaii. I think we need to remind people, and especially judges, of the role of the common law and access to judges. I mentioned in response to Mary Evelyn that we intentionally hobbled our government by constitutional design. Well, the quid pro quo was we still had access to the common law when we are injured. In every state constitution, there's a right to remedy provision and an open courts provision, which basically grants us a state constitutional right to access tort law. Because we knew that with a limited government, there's going to be harms, we're going to hurt each other, and we need some way to drag the harm doers into court, force them to be accountable before a jury of their peers, and provide redress to the victims. We need to remind people that tort law, it's very consistent with a libertarian constitution, which we have. So the conservative judges who want to limit access to tort law are misunderstanding that tort law was a premise of the libertarian constitution. So again, as I mentioned, I'm a tort romantic. I believe I could even sell tort law to libertarians, and that's probably a little bit of a reach.
Okay, join me in thanking Doug. Thanks, Doug.
Thanks.